Hello and welcome to series number 1 of an interview with the experts. My name is Yvette Barnes, salesperson with Right at Home Realty, and today we're going to talk about pre-construction contracts and the 7 essential questions you need to know. Today I'm joined by Alex Koch of Siegel Koch LLP, one of the legal experts at this firm, who will be answering some really key questions for us today. So let's get started. Hi Alex, how are you?
Hi, I'm great, thank you.
Great.
Thanks for having me.
Thank you. So we do have a few questions that we'd like to ask, and some of the clients that I've worked with would like to know, and I'm sure the public would also like to know a little bit more about what happens in pre-construction. So why don't we get started with a few questions?
Great, I'm looking forward to it. We have a lot of clients that always ask a lot of questions.
Excellent. So when a client signs a contract on the day of the condo sale, what does that mean?
So after a contract is signed, the client generally still gets a 10-day cooling off period, meaning they get to change their mind if they don't want the unit anymore. They usually, depends on the builder, they do ask for a deposit up front, but if the buyer backs out within that 10-day period, then the deposit goes back to the buyer.
Okay.
So just to clarify, the 10-day cooling off period means 10 days, not 10 business days, and the clock starts ticking as soon as you get your full agreement of purchase and sale that's been executed, or a disclosure package from the vendor. Usually during that time, and we get a lot of clients that come to us with that, you'd like to have your lawyer review the agreement of purchase and sale. You'd also, and it depends on the builder, some require it and some buyers just want it for their own comfort, but to go and get a pre-approval from their lender to make sure that they're able to take out a mortgage for that particular property. So if in that 10-day time frame the buyer changes their mind, they can still back out of the deal. If they don't, they let the 10-day cooling off period run through and then change their mind. It's possible for them to lose their deposit. We have had clients that that has happened to.
Okay.
Even if you can prove that you should be getting your deposit back, you always have to think about the legal fees that are involved and whether it's worth a legal battle to try to get any of that money back.
Absolutely. Okay. And so other than the purchase price, parking or lockers, what else would someone have to pay for when they're purchasing pre-construction?
I think this is one of the biggest surprises that people find when they buy a pre-built is the amount of other costs that aren't included in the purchase price. And you find them scattered throughout the agreement. There is a section in a regular agreement of purchase and sale that talks about additional costs, but they could also be scattered throughout the agreement, probably why it's important to have a lawyer help you review that agreement. But those costs could be anywhere from $30,000 to $50,000, maybe even more, depending on who it is that you're buying from. And that's a big surprise when you're buying a condo, let's say for $350,000, you didn't really budget for an extra $50,000. You're all of a sudden buying a $400,000 condominium, and that's where a lot of these surprises come from. So there's a lot of different types of costs that are included, so I won't list them all. Some of the key ones, development levies. Usually those would be capped in a typical agreement of purchase and sale, but the cap is pretty high. It could be $6,000 to $8,000 for just a one-bedroom apartment. It could be more for 2 or 3 bedroom, depending on the apartment. You have your occupancy fee, which I think this is the biggest surprise for people who buy pre-built condos. The way that it works is generally you can't transfer a property unless a builder has registered as a corporation. So they have to go through various administrative hurdles in order to get that. So until then, you can't legally become an owner of a unit because they can't transfer it to you just yet. But at the same time, your unit may be finished, so you can occupy it. So this is called the occupancy stage. So you can occupy the unit before you technically become an owner of it. And in that case, you get charged something called an occupancy fee. And the registration process for the owner, for the builder to actually become registered could take up to 6 months, could be a year, could be 2 years, depending on whether there are a lot of administrative hurdles that they have to go through. The 2 years is a little extreme, but
sure.
About 6 months.
Okay.
So if in that period you're paying that occupancy fee, it works out to be almost the same amount that you would be paying if you were paying a regular mortgage on that property. But this isn't going towards your mortgage, this is just almost a rent that you pay to live in that particular unit.
And those occupancy fees, who are they paid to?
They're paid to the builder.
Okay.
So the way that it's designed is the builder technically isn't supposed to profit from that, so
Sure.
any interest earned or anything does go back to the buyer.
Sure.
But if a buyer was budgeting to pay off their mortgage for 6 months, they're not, they're just paying rent in a way to be able to occupy their unit,
Right.
which could be good or bad. If you find that you're renting an apartment in downtown Toronto and you're actually paying more than what your occupancy fee is, then you could profit from that and actually occupy your own unit before
Sure.
you own it. So that tends to be one of the bigger costs as well. You also have to pay for various administrative fees that the builder has to deal with governmental authorities. They do charge administrative fees, and those are also hundreds of dollars for different kinds. You're paying for your sewer electrolyzation, you're going through with your water, your hydro, all of these installation processes. So there's a lot of additional fees that you're paying on top of your purchase price.
And so, with an expert like yourself, when you're reviewing those contracts, is it possible for any of those fees to be reduced by using a lawyer? Is it the same as if someone just looked at the contracts on their own?
I think it depends on what the builder is willing to fight for and
Sure.
what not. So it's very individualistic. For example, some builders may charge you to be able to sell your unit before a certain date. That may be something that you would be able to negotiate with them. So an individual wouldn't know what you can and cannot negotiate,
Right.
but it also very much depends on the builder. They'd like to recoup their costs as well. So for example, with things like the occupancy fee, the reason that they charge that is it helps them keep the building going while you can occupy the unit, but before they're actually able to transfer that. So would they be willing to let the occupancy fee go? Probably not.
Sure.
So it depends on the circumstances, who you're dealing with, and
Yes.
what the actual fees are that you're trying to get rid of.
Okay, great. And is it necessary to hire a lawyer to review an agreement of purchase and sale? Don't these contracts basically all say the same thing?
Well, there's no legal obligation for you to hire a lawyer to review these agreements. Unlike with a resale property where you have your standard agreement of purchase and sale, when you're buying pre-built, the agreements vary depending on who the builder is. And so there's no such thing as a set agreement of purchase and sale for pre-builts. They look very similar. There are a lot of common provisions that you see throughout, but none of them are the same. And so it's still a legal agreement that you're signing, and if you don't understand what you're signing, then you're still bound by something that you may not fully understand. Generally, we've had clients that have talked to sales representatives, for example, and that walk them through their agreement, and so they'll say, I know the agreement pretty well, possibly, but the sales representative is not on your side. A lawyer is there to review your agreement and look for things that you're looking for specifically. And there are a lot of surprises with new build contracts that people aren't aware of.
Thank you. And are there any special concerns to get approval for a mortgage from the bank or for a buyer?
So generally, as I mentioned before, there's either a requirement from the builder for you to get some sort of pre-approval, or you may want to go on your own and make sure that you're actually eligible for a mortgage before you go through. But keep in mind that when you purchased a new unit, it could take 2 or 3 years before you actually need that mortgage, before the transaction closes. And so the banks usually may promise 120, 160 days based on
Yes.
the pre-approval that you've received. So once that time period runs out, you don't really know. And a lot in your personal finances could change in that 2 or 3 year period. Generally, before the deal closes, you do have to provide proof of mortgage to the builder.
Yes.
In which case, you definitely want to make sure that you have that in line, because if on closing you don't have the necessary funds, you're considered a defaulting purchaser and you can lose your deposit. So you want to make sure that you are eligible. Just keep in mind that a pre-approval is not approval, so there's really no guarantee. There's been cases where if the bank thinks that you overpaid for a particular property, they may not give you the full amount that you need to purchase. So there's always circumstances. That's why it's important to be open with the vendor, be open with the lender, to make sure that you're still eligible for that particular mortgage.
Sure. Wow, that's interesting. Even I didn't know that, so good to know. And if you're purchasing pre-construction as an investment vehicle, are there any limitations on the ability to lease that unit once you purchased?
Yes, it depends. Like I said, there's no standard agreement of purchase and sale. Generally, you will see a provision in your agreement that says you can't lease out the property before the final closing day. Remember, you have your occupancy date, which usually comes before your closing date, so you have keys to your unit, you're paying that occupancy fee, but during that time, usually there's restrictions on your ability to lease out that particular unit. You may be able to negotiate before you buy, so before you actually sign the agreement of purchase and sale, to allow you to do that before the final closing date. Like I said, some builders can charge you an extra fee. It could be something like $4,000 just to get that right. On top of that, there's usually schedules or separate provisions in the agreement that the new tenant will have to sign, and they'll have to abide by certain rules. So this is, if you're a landlord, you have your tenancy agreement with them, and then you're also adding extra provisions on top of that, which may impede your ability to find a tenant that's willing to go through the hurdles.
Right.
And also, if during the occupancy time, the builder is still, usually the common areas aren't available, the builder is still finishing some of the units, so you have to get used to construction zones,
Yes.
noise, things like that, which also may impede your ability to actually lease out your unit before the closing date.
Okay. And when would I, as an investor, be able to resell a pre-construction unit?
So just like leasing restrictions, most agreements of purchase and sale will also have restrictions on your ability to sell before the final closing date. You can also argue, possibly, that you should have that in your original agreement of purchase and sale, just you should negotiate that point, that you are able. You may get charged, and there's also possible tax consequences, which I'd like to talk about taxes later, so
Yeah.
I'll come back to the assignment issue and taxes
Great,
as well.
thank you. Let's talk about that. And what if the unit doesn't look like the one that was viewed in the showroom?
So generally, the agreements of purchase and sale do allow vendors to make modifications.
Mm-hmm.
You will have a provision in most of them that will say modifications are allowed, and the modifications could be in anything, the colors, the furnishings, the appliances that are being used. They have to be more or less the same value as what you saw, but even the sizes of windows that you saw in the showroom could be different. Even the size of the unit itself could be slightly different because you don't know what the unit's going to look like. If you thought you were purchasing a unit on the 7th floor, you could have been moved to the 8th floor, depending on how construction went, because builders are allowed to change the number of units that they're allowed to be in a building. So there are modifications that are permitted. So one of the key pieces of advice is to not get attached to the unit that you saw in the showroom, because you may or may not get something that looks different. Usually, if there's a material change, then the builder has to give notice to the buyer. The buyer, again, has another 10-day period to decide whether they want to drop the purchase or if they'd like to continue with it. So I'll give you an example of a material change in a case.
Sure.
There was a person that purchased a unit that had a loft in the showroom. One of the reasons that they purchased that unit is because they were planning on using that loft as workspace, and the final unit didn't have a loft. And so the judge ruled that that was a material change, and that the purchaser should have been entitled to notice. One of the reasons they bought the unit in the first place was because of the loft, and so that was a material change. But you can see that the brands of appliances or whatever is used may be significant to a particular purchaser, but they probably wouldn't be considered material. It has to be something that's substantive.
And so we wanted to go back a little bit and talk about the tax implications. Tell us a little bit more about that.
So unlike resale units, generally when you buy a pre-built, there is a tax that's usually included in the purchase price. So you're paying HST on that particular unit. You are allowed to get a rebate for that tax, but if you're using that property as your primary residence. So you have to demonstrate to the government that you're using this as your primary residence. It's possible for people to have more than one residence.
Yes.
The key distinguishing feature is that it has to be your primary residence that you're using that unit for. What I see in a lot of agreements of purchase and sale is that you actually assign that rebate over to the builder. So even though you're entitled to it, because it was already included in the purchase price, any rebate that you get from the government goes to the builder. And going back to the assignment provision, so keep in mind, let's say you purchased a unit and you'd like to sell it to somebody else, you already assigned your rebate over to the vendor, but if you sold that unit, it's no longer your primary residence. So you gave up your eligibility for a rebate, and at the same time, you're still on the hook for the rebate to the vendor.
Wow, interesting. That's a big surprise, I think, for many people, particularly for newer investors that are looking for pre-construction options. And so I'm also wondering about a little bit about the upside of buying pre-construction. Can you talk a little bit about that?
Well, one of the key things with pre-construction is the value. They're usually worth less, and you're holding on to a document, essentially, up until the final closing date when you actually own the unit. So because you're taking on that risk, and you are taking on the extra cost that you normally wouldn't have in resale, eventually when the deal closes, you see a big jump in the value of that particular property. That's sort of the trend that we've been seeing. It, again, depends on the building and how it was constructed, but I think one of the key reasons that people buy a pre-built is, first of all, its ability to grow in value, and the second thing is, if you're not ready for that kind of commitment just yet, so you're thinking that maybe in 3 or 4 years I'd like to actually own something and then I'd like to take out a mortgage, well, this way it lets you sit on something that's not as expensive as if you bought resale, let's say, but then you also don't have to take out a mortgage right away and start making all of those payments immediately.
Excellent. Thank you so much, Alex. This has been very informative.
You're welcome. Thanks.